Okay, good morning, everybody. We'll get started with SB 78. Go ahead, Senator Gaddy.
Thank you, Mr. Chairman, members of this committee. My name is Senator Gaddy. I represent District 36 here today on Senate Bill 78. Senate Bill 78 is centered on my daughter, Rebecca. I have 4 daughters. My third daughter, Rebecca, was born on April the 25th of 2007. It was our third child. My wife and I are high school sweethearts. Went to LSU together, proposed to her at the bell tower. She's Baptist. I was Catholic, so we're Baptist. We compromised. And I just told her that we would have a whole bunch of kids. They'd all be saved. So we're pro-life. We're prolific. And that's my family in a nutshell. My daughter Elizabeth is here today. My daughter Rebecca and my wife Susan. My daughters Catherine and Charlotte are too high maintenance to be able to pack this quickly. So they're back in Bossier. But they're here in spirit. So let's talk about Rebecca's story. I was reading to Rebecca the night before she was born. It was a kind of a tradition with our kids that we would read to them while they were in Susan's womb. And Rebecca responded to our voice. It was really neat. She was the first child we had everything ready for. We had our room painted, the crib together. With the first two, we were so young that, you know, it was just tough to get everything together. We knew with Rebecca we'd have it all together, so we did. Susan went into the hospital with a little bit of high blood pressure, and the doctor induced labor. I received a phone call while I was at dance class with my 2 oldest kids. Called the mother-in-law, told her to come pick up the kids at dance, and then I rushed to the hospital. And things kind of progressed that night kind of eerily. There was a lot of confusion about what to do, and ultimately Susan was in great duress. Her blood pressure fell. Her womb tightened. It wouldn't relax. It was in a constant state of contraction. And there was kind of a debate between the doctor and the nurse what was really wrong. The doctor kind of thought, well, the monitor's just broken. The nurse thought there's something really wrong. And it took about 3 hours for them to decide to do a C-section. Later we found out from a friend of ours that's a neonatal nurse at the Health Science Center that based on her reading of the fetal strip, what she thought happened was that when the doctor thought the external monitors were broken, he put on an internal monitor and more than likely put it on Susan's uterus or cervix rather than Rebecca's head. So we had a false reading for about 3 hours. That was a delicate time for Rebecca. She began to die. Her brain suffered a horrible hypoxic ischemic event that was avoidable. When they finally decided to bring in a bedside ultrasound because of Susan's demise, they put it on Susan's belly and it read 50 beats, which was totally opposite of the fetal heart strip. So they knew there was misplacement. In a typical situation, we found out we were at Dallas Children's that if there's an emergency situation, you can typically get a baby out in about 3.5 to 7 minutes, and that's the standard of care. It took about 28 minutes between the time they did the bedside ultrasound to get enough staff onto our floor to do a C-section. And so when Rebecca was actually out of the womb, she was dead. Susan was awake. She had local anesthetic during the C-section. So she saw Rebecca laying lifeless on the table next to her. Rebecca had, they do an APGAR score on babies when they're born, and typically there's 15 is what most kids have, or a 14. They test, different hospitals do it different ways, but it's typically color, breathing, and heart rate. You know, they take those things, that's how they gauge a baby when they're born. Rebecca had 0, 0, 0 APGAR scores at 1, 5, 10, and 15 minutes. They continued to give her epinephrine. I was not in the room. They continued to give her epinephrine and woke her up. We found out later at Dallas Children's that not only did they kill Rebecca, but they shouldn't have brought her back. And as a dad who's pro-life, I said, come on now, that's kind of odd. We're all supposed to fight for life. And the guy at Dallas Children's told us when she was about 8 months old, he said, you'll be changing her diaper when she's 9. She'll have so many seizures, her hips will be out of socket. And I said, that's ridiculous. People with brain injuries don't suffer like that. So we had never seen, in all my years of practicing law and Susan being a PhD psychologist, we had never seen a child as bad as Rebecca, and Dallas Children's had not. I think it's because Susan was so healthy during her pregnancy, unlike me. I drank the ices, I ate the red meat so she didn't have to. I stood up to the plate, took a bruise for the team. She is very healthy based on her research as a psychologist, and so that's kind of what happened. As we began to think about it, we asked the doctor, what went wrong, and he explained to us that it was Susan's tilted uterus. It was probably a genetic problem. And so we had to go through some genetic testing on Rebecca, and we were kind of in the dark. Finally, I was at a thing called Pumpkin Night Light. It's something on Halloween public schools do where they carve jack-o'-lanterns and you walk down a trail. And this lady grabbed me and said, you know, he's hurt some other kids. I said, ma'am, who are you? I'm standing there with my two oldest daughters. My wife's at home with Rebecca. And she said, you know, he's done this before. I'm like, whoa, who are you? She was a nurse at the hospital who had heard our story. So that began us in a long journey of discovery. He told us that we probably shouldn't have any more kids because of Susan's biology. That was upsetting to us. And 6 months after, or a while after Rebecca was born, he was no longer with the hospital. His partner asked Susan to come back to the clinic because Susan had been at that clinic since she was a teenager. And I just asked one question to the partner. I said, can we have more kids? That's all I want to know. It's hard for us to even walk in this hospital after all we've been through. And he said, yeah, there's nothing wrong with y'all. Y'all can have more kids. So that was really the only time I really broke down, you know, when this happened because, you know, pro-life, prolific, I had to stand by my word. You know, I wanted to make sure we could keep rolling. Well, we began to look at this, and as we met more and more families, like Riley, we met Kai and Jude about last month, and just sitting at Shriners, you meet folks, and when you have a child with a horrible brain injury, it only falls into two categories: a genetic disorder or a trauma at birth or right after. So we began to look at that and kind of putting the pieces together, and Susan and I began to advocate for that. Now, as part of our case, we had to go through litigation. Susan had to resign from her job at the Health Science Center as an associate professor. I basically decrescendoed my practice and took a job as a workers' comp judge, and so we put our life on hold. And as the case was going, we were told, look, you're not going to win. You're not going to win this case. It's hard to win the panel process. My friends told me that. Some judges told me that. And just said, look, just do the best you can for your child while she's here. And we thought she would pass away within the first 2 years based on her global brain injury. Well, as we began to search for answers, the lawyer called us one day and said, hey, we got the panel opinion back. And I said, well, look, I know we probably lost. He said, no, it was unanimous against the doctor. We rarely see these. And I said, well, explain that to me. He said, well, we picked a doctor, the doctor picked a doctor, and then the state picks a doctor to sit on a panel. They just look at the cold record and they determine if he deviated from the standard of care. And I said, so he deviated from the standard of care? Yes. And then we said, okay, well, what does that mean? It means that your daughter's brain injury was caused by, not by your wife's tilted uterus, she doesn't have one of those, not by any genetic thing. It was he missed several opportunities to save your child's brain. And they were textbook late decelerations, you know, several hours before he decided to do the C-section. Well, so we got the lesson in forgiveness. You know, we had to go through that. It was difficult to explain to my retired commander in the Navy, father-in-law, who watches more Fox News, I think, than O'Reilly, that his daughter's brain was worth $500,000. You know, he saw the devastation Susan and I went through. He saw me warming up breast milk and feeding Rebecca like a baby bird. When we would go to church, he would be the one he would come to our house and watch. You know, and this is a Vietnam veteran, naval officer, and then retired again from a great job as a vice president of a construction company. And he was completely befuddled that Rebecca's brain was valued in 1975 and 76 at $500,000. And so we kind of struggled through that. And so as I was on the campaign trail, more and more people became educated on the fact that a baby's brain is valued at $500,000 in the situation where they struggled through a birth injury that was avoidable. And so we began to talk to some other families and talk to some different people. And I explained to them that this bill won't change your situation at all. Many people, I want to be careful how I say this, because Susan and I were in a situation where we were fortunate enough that we didn't have to file bankruptcy when we won our case. Most people, when they win, file bankruptcy because it takes all your savings, everything you've got all the favors you call in. It's a tough thing in these situations. So we began to talk to folks, and when the Oliver case came out a few years ago, and we were all watching that case because this was a horrible case. I think it was a nurse case. A nurse had failed to diagnose cancer in a young child, and so that child went without treatment for about a year, and the child had a devastating life after that. The court said, yeah, that if the nurse would have caught it, wouldn't have been as much harm. And so, but the court said, emphatically, they said, we're basically, this is my version of what they said. They said, we're so tired of reviewing the constitutionality of the Malpractice Act, we're going to scream it from the rooftop this time. The legislature has the power to set the cap, not us. They have to do the balancing test. They have to balance the level of safety in the community with a value on a child's brain. And so they said it loud and clear from the state Supreme Court, that the cap is constitutional and that it is our duty as legislators to review that, like other states have done, and determine if the cap needs to go up, down, or changed. So this bill really focuses on the following. With broad strokes, the current medical malpractice procedure is this. You file a letter with the Patient's Compensation Fund. They impanel 3 doctors to look at the medical records and depositions. The panel makes a decision, unanimous either way, 2-1 either way, and then the plaintiff has a right to file suit in the district court where the harm happened, and then they move forward with their case. That's the procedure in broad strokes. What this bill does, and I'll tell you that the ultimate end result of that procedure is that if a jury comes back and says, hey, your child's brain and all you went through, that unanimous panel, we feel like a fair trade value of your child's brain is $7 million. Plus, that includes the pain and suffering, your wife's loss of earning capacity, whatever it is. And they say that's our fair trade value. Well, the judge then thanks the jury for doing their job. They leave the building, and he says, by law, I hereby reduce this award to $500,000 plus future medicals. So many families do not try these cases. Sometimes the cost of these cases eclipses what they're awarded. All right, because experts are very expensive, and so a lot of times, you know, we struggle through that with families who call us and say, "Hey, we got a huge verdict. Hey, we can make ends meet," and then, "Hey, no, you can't. You only you're reduced to $500,000, then you pay your cost out of that." So they're left with the residue of that. So what this bill says is real simple. It says, okay, Supreme Court, you told us we have to review this cap. You've told us in Oliver and Butler that it's okay to have 2 classes of people. You know, our Constitution says if you get full recovery if you get harmed. 2315 in the Civil Code says if you do harm, you've got to pay for it. We have 2 big exceptions to that rule, which is workers' comp and med-mal. In Oliver, they said it's okay to have 2 classes of people. You say, well, what are the 2 classes of people? I thought we had equal protection. Well, this is the exception because they allow the legislature to do a balancing test, is you have 2 classes of people. Let's say you go in to the hospital and they say you have cancer, or you have cancer, they misdiagnose it as a lump on your back. Let's say you go to a physical therapist, he says, oh, that's just a lump, we're going to work it out. Well, it happens to be a tumor in your muscle. All right. That's a misdiagnosis. Let's say you go to your doctor 2 weeks later. He says, oh, we caught it in time, and they cut it out. Well, that claim is probably worth $25,000 maybe because you just had a few weeks where you were scared to death and the cancer didn't spread. Well, you get to recover 100% of your harms and losses under the cap. Let's say your case is worth $490,000. You get to recover 100%. So that's the first class that recovers 100%. The second class is the people like my daughter Rebecca and Riley, who suffer a traumatic, permanent, avoidable brain injury that affects every part of their life, and they get to argue about, are you going to get 500 or 475? Well, we'll give you 475 because we only get 500 if you try your case. You see, that's the negotiation that happens in a catastrophic brain injury case with a child. So let's talk about what this bill really does and kind of get past the fears that have been shared with a lot of people. First of all, the bill only deals with 1 class of people. The class of people that it deals with are people who haven't reached their 18th birthday yet, children. We already set aside some things for children in like first-degree murder. If you murder somebody under a certain age, it's first-degree murder. So we children are our hope and our destiny and our future. We protect them. And so this is from fetus, a child in the womb, all the way up to 18th birthday. That's all it covers. Secondly, that child must suffer not a mild brain injury. There's 3 categories of brain injury. There's mild, moderate, and severe. So it has to be a moderate or severe brain injury. Moderate or severe brain injuries are objective findings on an MRI. Any judge or neuropsychologist can look at an MRI and say that's at least moderate, probably severe, without even seeing the patient. So it's the most extreme of the two. But there's a second phase to the injury that's real important. You have to have the brain injury, and the brain injury has to cause an orthopedic component, meaning that you have to have partial loss of use of one limb, which we see in a lot of cerebral palsy cases from birth. You have to have paraplegia or quadriplegia. So even if you have a moderate or severe brain injury, if there's not a component that affects you, your muscles, so to speak, then this bill would not help. So that's the category of people we really want to help, because they're the worst. They're the most catastrophic, and it's the most injustice for them to be valued, for their brains to be valued at $500,000. Secondly, the procedure has a wrinkle in it in the bill, and it's a very important wrinkle. And that wrinkle is when you file your letter with the PCF and the doctors are impaneled, you have to get a unanimous panel, which those of you who have studied this or sat on commissions before, you know it is a rarity for a plaintiff to get a unanimous panel. I think 12 to 14% of the claims that are actively accepted actually go in the plaintiff's favor. And I don't have the actual number on that. Maybe some of these other speakers do, of how many are actually unanimous for the plaintiff. So it's a narrow category and a very narrow group of people. And once again, the Supreme Court said we can do this. We can do this. So the difference would be is if a child under the age of 18 suffers a catastrophic brain injury and there's a component of partial use of one limb, paraplegia, or quadriplegia, then they would have to win their panel unanimously. And then if there's a settlement, that settlement would include up to $5 million. Now, in all honesty, I want to make it clear that if you take your child's case to trial and you get $15 million for harms and losses, you don't get $15 million. This is not an uncapped damage. The judge will dismiss the jury, and he'll say, I hereby reduce the verdict to $5 million. So it's a known risk. It's not unknown. I mean, we know there are possibly, on average, 4 of these cases a year, and it affects families, grandparents, aunts, uncles, the whole family. It affects a lot of people. And so that's what this bill does. So I want to didn't do this in Jude, but because I know y'all may not be familiar with this, but I handed you a document, and I want you to just kind of look at this document if you have it in front of you. This is a review panel opinion, all right? And on page 1 is the letter. It was to our lawyer offering the opinion. The second letter is from the fund. The third page is the opinion of the review panel. Now these are rare, so I wanted to show you what one looks like. On page 3, it says that we hereby find, and number 1, the evidence supports the conclusion that the defendant failed to comply with the appropriate standard of care charged in the complaint. That's the first finding the panel makes. Secondly, this is 3 doctors. 3 doctors on number 2 said, and they were all OBGYNs, they said the conduct complained of was a cause or factor in the resultant damages. Now, this is unanimous, and one of the doctors was picked by the defendant. Now, we've highly redacted this so you don't see his name, you don't know what hospital it is, and all those things. Third, these doctors made a unanimous finding that the plaintiff, which is Rebecca Gaddy, my third daughter, suffered severe brain damage which resulted in a severe disability which is lifelong and irreversible. I met Ben Carson up in Shreveport. I showed it with my laptop when he was speaking somewhere. And I said, hey, I bought 10 of your books. Can I have 2 minutes? I flipped open my laptop and I said, you see this MRI? Ben, you name the price. I need you to fix my daughter. He said, you pray over this girl every day. She's an angel. So if he was on this panel, he'd agree with this. When we got to Dallas Children's, the first question they asked us in the ER one night is, did you have this baby in a hospital? I said, yeah, I did. We did. I didn't. My wife did. Yeah, we were there. We were in the hospital. So these things come up. Now, the rest of the opinion just kind of lays out the logic that our panels do. So the panel reads through every page of the record. They plow through it. They mull it over. They think about it. And then by the time their deadline comes around, they meet together. They meet over the phone or meet in person, and they make decisions. And what their decision was that, hey, there were a lot of telltale signs here to show that this fell below the standard of care. Now, the last 3 or 4 pages is where all the doctors had to sign off on it. Okay? Now, I wanted to share this with you because most of y'all have probably never seen a medical review panel. This is the ultimate end result of the medical malpractice cap. This is what my wife and I received in the mail. And when you receive something like that, most people think, wow, those plaintiffs must be jumping up and down. Woo! It was devastating to our family because we really hoped in the back of our mind that this would say there's nothing he could have done. They used the best technology. They had the best people. They had the best training. Mr. Gaddy, we're so sorry, but there's nothing that could have been done. And in fact, we found out that there were several things that could have been done, and they weren't that complicated, and they were at the disposal of that hospital. So why the brain? People have asked me this, and I want to bring it up to y'all. Ryan, why does this on Senator Gaddy? Why does this, or Representative Gaddy, whatever they call me? Why does this? Why'd you focus on the brain? Why? I was going on a trip with my kids, and we stopped at, I think it was Love Field or somewhere, and we always try to buy National Geographic to read on the plane, and they dedicated an entire issue to the human brain. And as we went through this with my kids, it was kind of neat because, you know, when you ask a child what's a brain, they'll say, oh, that's how I can throw a curveball. My dad says I have good hand-eye coordination, or that's how I memorize piano, my brain. And so kids see brains differently. And so when we talked, when kids ask us about Rebecca, when we're at church or different places, hey, why is she so small? Why does she look so different? And we say, well, you know, her brain's hurt. And then we ask them a question because, you know, they're struggling to piece it together. And they'll say, what does your brain do? And they kind of say some of the things that National Geographic said. So Senate Bill 78 is simply a reaction to the most recent Supreme Court case that said they don't want to hear constitutionality arguments anymore. They've said over the last 40 years that this situation is constitutional and that we as legislators have the obligation, responsibility, and the duty to review the medical malpractice cap like other states have done. So I thank you for your time. I'll answer any questions if you have them.
All right. Senator Johns has a question.
Thank you, Mr. Chairman, and Senator Gaddy. Thank you and Susan for your courage and for sharing your story with us this morning. Tell me about Future Medical. You
Right.
brought up Future Medical. Tell me how that works and maybe I'm sure if anybody at this table understands how it works, it would be you. So
Thank you.
Could you walk
Sure.
our committee through Future Medical?
Sure. It's kind of ironic. In Rebecca's case, we settled her future medicals because her life expectancy was about 2 or 3 years. Now, she's 9 today, all right? But we had the means. We weren't going to wait in line for a van. We weren't going to wait in line for the state to approve her Keppra. You know, we were getting cutting-edge medicine for her seizures.
Can you explain that, though, what you mean by that?
What Keppra is? Or
No, what you're talking about when you have to wait in line?
Oh,
What-
yeah.
what
I was a
is that?
workers' comp judge for 2 years. That was one of my favorite side jobs. All right. When I used to watch paint dry, that was probably my favorite job. But comp would probably be second. And what we noticed is that the Patients Compensation Fund uses the workers' compensation schedule as their way of paying claims. Now, as a workers' compensation judge, I saw many times people that needed rotator cuff surgery, but it would never get approved under the schedule. So when I heard that Rebecca, I mean, you have to realize this too, there are no pediatric guidelines in workers' comp. All right, so if I had to ask them for a deviation from the standard in the schedule so we could go see a pediatric neurologist in Dallas, can you imagine just the, and when you lose 2 weeks with a child having seizures because they've built up a resistance to the medicine they're currently on, and you want to try baclofen instead of Keppra, or you want to do you want to go somewhere where they'll give you a higher dosage through an IV. I mean, you don't have. I mean, when she's having diarrhea and she's seizing so much her hips are out of socket, you really don't have time to go through the state and get approval. So we just made the decision just to get all this in our rearview mirror. You know, I mean, we have a lady that we pay to sit with her every day out of the house. You know, I think that would have been a struggle to get that approved. I think if we needed transportation for Rebecca, it would have been a struggle to get that approved. So, yeah, future medicals are great in theory, but what we find practically as we meet some of these families is that it's a very difficult, it's kind of like workers' comp on steroids. You know, it's a very narrow gate. Now, I think they do a great job with protecting the fund. They have an obligation to make sure, you know, claims are not paid frivolously. But I think by picking the workers' comp as the gate by which these things are approved, it's kind of it's not what it's cracked up to be, but it's not bad. So,
and I asked that question because in my earlier years when I was in the House, there was a particular med mal case in my old House district, and I followed it pretty closely. Eventually, the young person died. I think the young man actually grew to be 24, 25 years old. But at the time of his death, I think at that time, and I don't know if there's some bigger cases, at that time, I think it was one of the largest in the state, maybe the largest. And they had paid out something in the neighborhood of $12 million in future meds on that particular case. So I remember that number. So I think they even actually built a room on to their house to accommodate them to be able to keep the child, you know, in a safe and in a comfortable environment. So anyway, I'm just kind of was very curious, you know, how that worked. That's all I have, Mr. Chairman.
Senator Gaddy, on future medicals, I know you pointed out the process by which you get approval for whatever that future medical might be. I have to assume that part of the cost is not necessarily just technically medical in nature, as much as it is having somebody as a caretaker for the normal everyday things you do in life.
correct.
Does future medicals cover that type of care?
You know, we weren't. We didn't use it at all. I mean, we just settled that. I think for maybe I don't remember even the amount. You know, but we just wanted to. We did not want to be going through a process to get approval for Rebecca for different things. But I think Ms. Frugier may be able to speak to that more because she's actually going through those processes of getting stuff approved. So.
Okay. Go ahead, Ms. Frugier. I'll let you go forward, but we have some more questions. But so stay put for just a minute.
Hi, my name is Mona Frugier, and this is my grandson, Riley. Riley has quadriplegic cerebral palsy. And Riley's cerebral palsy is due to malpractice by the hospital he was born in. They neglected to see about the issues that my daughter was dealing with when she was in labor with him, and it got pushed aside, and Riley ended up being born not breathing. So his is with lack of oxygen to the brain.
Hypoxia. Did I don't know if you know all the details, but did this case go to a medical review panel? Was there a suit filed? All that kind of
yes,
stuff?
Yes, it did.
Is
and
it the
the
same
hospital
scenario?
was found at fault. So we deal with PCF now.
Okay. Do you know what the panel voted at the medical review panel stage?
They voted that that the nurses were found at fault.
Okay. Was it unanimous?
Yes, yes, it was.
Does your grandson require, is it 24-hour day care?
Yes, it is. It's 24 hours a day care, and I am the one that sees about him all the time. I take care of him. I'm his caregiver.
Okay. Senator Appel.
Yeah, I was really curious, Senator Gaddy, about a couple of things. In the bill, and you made this point, you say that the definition of a child is from a fetus in utero. I'm just curious how, I mean, I know very little about medicine other than what my wife has taught me because she was a nurse. I'm curious how, yours was a problem in delivery, and I can see the mechanical aspects of that. But what about a child that's just has a problem after 3 months or something, and how do you define when the doctor made a mistake?
Oh, you mean like a brain injury?
Yeah, to cause an injury that would develop into a brain injury at birth.
Well, I'll tell you, as technology gets better and better, I'll give you an example. A CT scan doesn't always show a brain bleed right when you have a trauma. So sometimes a CT scan 2 weeks out shows a brain bleed. But with a hypoxic ischemic event at birth, it's typically the gold standard to determine the child's brain injury is an MRI.
Right.
So,
Yeah, well,
yeah.
that's what I say. I understand the birth part because I've had a niece who had a problem. My daughter had a problem. We had to do an emergency C-section. I can
Right.
remember what happened.
Yeah,
But that was at birth, and that was. But this covers all the way for 9 months.
Oh, okay, I see. So let me give you an example. We've met folks who take their baby in to a nurse at a quick care or whatnot, and she says, "Oh, they just have strep. Here's some antibiotic," but it's actually double pneumonia. All right, so that child goes home and asphyxiates, either throws up or swallows their phlegm, and it's a little bit because with babies their tummies are so small, and then it causes a hypoxic ischemic event. Meaning,
but wait.
Yeah.
You're ahead of what I'm talking about. That's post-birth. I'm talking about a mother who is pregnant, let's say 3 months.
Oh, okay. Yeah.
And because your bill covers everything from conception to birth, and I'm trying to figure out how you.
I think it would only apply to the times near birth. Yeah, that's
Then
the.
it says from a fetus in utero to birth. Let me get the words. I'm sorry.
Yeah, it's on page 2, line 28 and 29. It says, child to lose partial or total use of one limb or become paraplegic or quadriplegic, and child means a fetus in utero or any natural person under the age of 18 years. Yeah, we could limit that to.
I'm just curious. I mean, it seems to me it becomes very difficult to define what was the actual cause of a child having a brain injury at birth.
True.
That could have occurred because of anything. I don't know.
Well, and what we find, I guess, to answer your question the best, because it's really about causation, and causation is an opinion that the panel gives. So let's say someone feels like that because of something that happened, maybe a medicine a mom was given at 3 months, that when the doctor gave her that medicine, it had a known risk of affecting the fetus, and that when he gave the mom that medicine, the fetus suffered a lack of oxygen through the red blood cells of the mom. Okay, well, she has the burden of proving that.
Yeah.
She has the burden of filing the letter, finding an expert to say that. I think is it possible, of course, but if the panel would, 3 doctors would decide whether or not the hypoxic ischemic event was caused by an event during the pregnancy. And once again, for this bill to apply, that child would have to have such a significant brain injury that they would have to read like our opinion. It would have to say, breach the standard of care unanimously, okay, that the injury was caused by
Right.
the breach. And so it goes back into that narrow panel process. We have a whole bunch of people open the gate and go in, but very few make it to the other side. We're expecting 3 to 5 a year.
Do these legal processes, are they like an arbitration, or do they require a great deal of discovery, and how does the lawyers get paid? I just don't know how this works.
Sure.
I mean, in other words, you got a panel of 3 doctors. So
Correct.
do you present the case like you would present it to a judge?
What you my understanding is you each side writes a position paper, and they share it with the panel and the panel's attorney that's been appointed, and that.
So the
I really don't
research
know.
and the discovery
Yeah,
is
all
done
that.
by the panel, not by.
No, it's done by the people. So
People.
it's I mean, for instance, the attorney for the hospital could have taken my wife's deposition in the panel stage. He could have taken my deposition. I could have taken the doctor's deposition. We could have experts look at the medical records. It's really a trial by panel.
Right.
So it's similar
like
to
an
what-
arbitration.
It's similar to that, but it's not binding. You can still go to.
Senator Appel, I've presented 4 cases to the medical review panel just this past year.
Yeah, he's
So
probably
you
better than
present you can take depositions, you can gather up evidence, you can incorporate it in your memorandum to the panel. The panel each side picks somebody, the PCF picks a middle guy, and then they can come back with an opinion. In this case, this opinion came back 3-0.
No, I understand that. I
But
just
even
didn't
if
know
it
how
had
the
come back
process
3-0,
worked.
even if it had come back 3-0 against him, he still has the right to file a lawsuit despite the findings of the medical review panel. So it's not binding arbitration. It's not binding at all. So you still have an opportunity to bring your
Cap is
lawsuit.
binding.
The cap is, yeah, it's that.
Okay, so
that's
even if
done.
he filed litigation, he would still be under the cap.
Yep.
Correct.
Regardless of what the
Now,
opinion came back.
One last question, and I'm going to quit. But it seems to me, I have friends that are doctors, not related to this field,
Right.
obviously, but and they've told me over the years that there was some negotiations relatively recently in the last few years about caps in general, and between the doctors and the lawyers and all those involved. Are you aware of any history of that? I can't speak to it because I've heard it.
Well, I'll tell you, and I don't know, but I'm going to tell you what I've derived through different conversations is that there was a big push a few years ago before the Oliver case came out. And the talk was, we're going to agree on, like Indiana did. Indiana, which we cut and pasted into our law, Indiana's law. Indiana went from $500,000 to 1.25, and their Republican-controlled Senate just bumped up their cap to like 1.68
And
for
that's
next
for
year.
all.
Yes, all of
Everything.
them. All of them.
Yeah, well, that's what I had heard, that there was some discussions of that in general across the board, not just narrowly tailored to one.
Well, and that was
but
the
I
thing.
just didn't know what the status. And
Senator Pell,
curious.
I think what happened is once our Supreme Court ruled the cap was constitutional, there was no reason to negotiate anymore to raise the cap. Because once the Supreme Court said this is constitutional and creating those 2 classes is still constitutional, the legislature did this balancing test and it's fine. So the pressure was kind of off, so to speak.
Right.
To come up with a compromise before the court ruled. So once the court ruled, all the negotiations, I think, stopped. This bill has started those negotiations again, but quite frankly, you've been to a lot of arbitrations. I have too. I mean, this is something that this bill specifically for the few children each year that suffer the worst injury you can suffer from.
But my last question was just a broad question, and that was, don't you think that it would be more appropriate instead of? I understand the significance of this problem, but there are other issues, medical issues that are still under that cap. Wouldn't it have been more appropriate to order a group of the competing sides to come up with negotiations on caps in general?
Well, I think that's always available, and I thought that was going on when I got elected.
Right.
But what I found was that all those negotiations stopped once the Supreme Court said it was constitutional. So it was kind of like saying, hey, I'm going to negotiate with you in good faith. Let's get this thing worked out. Oh, the court just ruled, we're done. Now, if the court would have said the cap was unconstitutional, I'm sure the other side would have stopped negotiations. So but the court did something very wise. They say, give to Caesar what is Caesar, give to God what is God's. I'm not giving you a yes or a no.
No, I understand.
They say,
Okay.
that our y'all's committee can decide the value of a child's brain, and that's what we're
I
stuck
recognize this is an extremely, besides the emotional side, it's an extremely complex issue because it
Very
does
complex.
involve substantial amounts of funds and insurance costs and other things. So it's a hard call.
It is a hard call, and when I found out this only happened to about 4 kids a year, from the testimony in Jude A. And you say, well, if all 4 of those get a unanimous panel, which would be unheard of,
Right.
then the maximum that could be recovered is $20 million. The PCF currently makes that much in interest every year on their over $1 billion in their account.
And you did take the states out of this, so any injuries that would occur under Medicaid or
I don't
mean,
think that amendment the amendment's on our website. It has not been
Oh, I thought we
offered.
adopted
I
that.
think there is some resistance to that from some of the opposition.
I see.
And so I wanted to hear what they had to say before we fought that fight, because they feel like, oh, well, I guess everybody's going to move to work for LSU now, and so I was like, well, that wasn't my intended.
Yeah,
that
no,
wasn't
I
my
understand.
intended consequence. So
I understand. Thank you very much.
Thank you, sir.
So, Senator Gatto, I guess I want to ask Ms. Frugier again. When something like this happens, do you have to make I'm assuming you have to make modifications to your home. I guess your daughter made those modifications.
We have not yet made modifications. None of that has been done yet.
Okay, but for wheelchair access, bathroom, all those kind.
None of that's been done yet.
Okay, but
That's
I mean,
PCF. We have not dealt with PCF with that yet. We're having issues with getting a new van right now.
okay, but the PCF has a process by which those things can be addressed.
Supposedly, like I said, we haven't yet addressed those, which it's getting to that point where it's time. He's getting to where he's a handful.
All right.
Yeah.
And does the PCF cover the cost of the 24-hour?
Yes, we get,
Care?
Yeah, $7.45 an hour. $7.43, excuse me.
Okay, and the $7.43 an hour, is that that's the workers' comp schedule that you were mentioning earlier? Okay.
It's $7.43 an hour that the caregiver gets paid to watch the child, and the caregiver typically is the mom or the grandmom. So it's a family member, and we know from brain injury cases that when you rely on family, like I can't do Rebecca's physical therapy on her legs. I have to leave the room when the physical therapist comes over because I cannot watch that. I can't watch her scream. I cannot. I mean, that's just dad. Dad kicks in. So in essence, only the parent's going to do it for $7.43 an hour. And a lot of folks
Because you can't find somebody at that hourly rate, I'm assuming.
we can't find somebody for more than that. So it's tough.
Okay. Senator Tarver and then Senator Hewitt.
How long have this cap been on for this particular situation, $500,000?
1975, so it went into effect 1976.
So it's been $500,000 in 1976?
Yes, sir.
Have not been increased at all?
No, sir. There was a time in 1984 where the Supreme Court ruled that medicals would be unlimited because, as medicine advances, I mean, babies like Riley and Rebecca are living longer, so the cost goes up. And so they said this will be unlimited medical. So it's $500,000 plus unlimited medical, and that was the change from the '76 decision of $500,000. But it's always been $500,000 in Louisiana.
Okay, thank you.
Yes, sir.
Senator Hewitt.
Thank you, Mr. Vice Chairman. Senator Gaddy, first I'd like to thank you, and is it Ms. Frugier or Brugier? Frugier, for coming, and Susan, and sharing your stories with us. And I'm going to ask you to forgive me for a few minutes because, this is the Finance Committee. And so part of my job and part of our job is to ask about the numbers. So I'm going to talk about the numbers, but I don't want you to perceive that as a lack of compassion.
No, ma'am. We understand.
So I'm a little bit confused about the fiscal notes because we actually have two fiscal notes online, right? One, from what I understand you're saying is that the original bill and the original fiscal note is what we should be looking at, which includes the state insurance and the state employees, that they'd all be part of the bill. Is that correct, Senator?
At the current stage of what we're talking about today, that is correct.
Okay. Okay, so what the fiscal note says, my reading on it, and I want to again ask you to make sure I'm understanding this correctly, is it explains in the expenditures section that the average total of all medical malpractice claims paid from fiscal year 12 through 14 was $13 million. Okay, so that would be using the $500,000 cap, because that's what's in place currently.
Yes, ma'am, and I think that's all medical malpractice claims, not just babies with brain injuries.
Okay. Well, that's a.
Well, maybe
I don't know.
Maybe
Don't know that question.
Maybe I'm misspeaking on that.
Okay.
Well, let's just assume for the purposes of your question that the fiscal note's correct.
And we have someone from the fiscal office that we may ask to come to the table in a couple of minutes to help clarify what was built into his assumptions. But so, in my way of thinking, if you translate that from, and I understand that not everybody got the $500,000 cap, so there's a lot of assumptions in my numbers here. But if you just increased it tenfold, which is what we would be doing by raising the cap from 500,000 to 5 million, you could be talking about, a tenfold increase in the cost to the state. We're talking about $134 million potentially.
And Senator Hewitt, that is, we have a couple of levels here, and the reason I wanted to have the fiscal office discuss my amendment that took out all state and government entities, and that was because the state already enjoys a $500,000 limit on liability in all of their entities. I think that's correct.
Yeah, that's it.
Okay, and so it would not make sense for the state. So the state's liability, like DOTD, is equal to the med-mal cap. So during tort reform in the 90s, we gave the state some immunities and some caps, okay, to solve our budget crisis. So that people wouldn't be able to sue DOTD for a brain injury. They could get $500,000 plus some future expenses. So in discussion with the state, in discussion with some folks, I decided to offer an amendment that excluded the state in these cases, because then it would keep us on par with the immunity and caps the state already has. This would have been the only situation where the state could be sued for more than $500,000. And he says, well, how can you do that under equal protection? How can you treat a hospital here different from a hospital? And well, the Supreme Court has already said we can create different classes of people under the Medical Malpractice Act. The people that collect 100%, the people collect pennies on the dollar. We just have to balance that out. So my amendment would be to take all of the burden off the state. And the testimony, I think, will be from the fiscal office is that it would zero out the fiscal note. But the other day on another bill that is similar to this in health and welfare, the opposition stated strong opposition to creating the two. So I mean, I'm trying to ultimately your committee will decide on the amendment and whether or not it's accepted or not. But I wanted to give opposition a chance to answer that question, because I'm not really sure what the basis is for not letting the state out. I mean, that's what most people do when they come to this committee, is they amend the state out.
Well, I wouldn't. I would beg to argue that that's what most people do, because I do agree with you that what's kind of good for one is good for all citizens in our state. And so, I do in general support that kind of philosophy, and I don't like amending the state out just to zero out a fiscal note to get it through the finance committee. So I'm not sure that I completely agree with that. Why don't we, I don't know if this would be the appropriate time, Mr. Chairman, to get some clarification from the fiscal office on the fiscal note, or if you'd prefer to do it in a different sequence.
Just a point of order, Mr. Chairman. Do you mind if we let Ms. Frugier finish her testimony so that she can leave with her grandson?
Yeah, and we have some more questions probably for you, and then we'll get the fiscal guys to come up and kind of go through the fiscal deal.
Thank you.
So, Ms. Frugier, why don't you go ahead and provide your testimony?
Okay, well, Riley, I think I went through the birth part as to what took place with him. Riley was about 8 months old when we decided to get an attorney, because we knew we needed help with him. And it took about 5 years. for everything to go through and for everything to be settled. He ended up, by the time we finished paying all the medical bills and all of the stuff that Medicaid put out for him, he got about $180,000.
So I'm assuming you settled the case, or did you go to trial?
It didn't get to trial because the hospital wanted to settle out of court because they knew they were at fault.
Okay, and you were, I'm assuming, compensated in the amount of $500,000.
Yes.
And you retained, you did not settle, you still have the right to pursue future medical costs. I think that's what you were explaining.
Yeah.
So there were about 300 and something $1,000 in cost?
Plus the lawyer fee, with the lawyer fees and everything else included, yes.
Okay.
That's what it was.
And your medical costs from the time of this incident to the time that you got you're settled, Medicaid paid that?
Yeah, but we had to pay it all back.
And that
Medicaid had to be paid back.
Okay.
Yeah. So, and by the way, we come from the city of Eunice.
And I represent Eunice.
Yes, sir.
Yes, ma'am.
Okay. Well, Riley, it's just like I said, I have to do everything for him, from getting him up in the morning. I'm up early, bright and early in the morning, trying to get all of his stuff taken care of, his clothes, his medications, getting him fed and getting his braces on, getting him his food and stuff ready for him, because he can't just eat when anybody else eats because he's been diagnosed with celiac disease.
Ma'am, are your your medicines and braces and any ancillary medical services like therapy or any of those kinds of things, are those being paid for right now?
Yeah, they're being taken care of. Some of it by PCF and some of it Medicaid is paying for. Okay. So, yeah, it's just it's a long day. I mean, from early in the morning till time for him to go to bed, and I'm his main caregiver. I take care of him.
All right, that's a lifetime commitment.
Yes,
There's probably
it
no
is.
amount of money that can.
And he has his therapies. I mean, he has private therapies. He's got his OT, physical therapist, occupational therapist, speech therapist. Plus, he has it through school. He gets it through school also, which Medicaid, which I just found out that Medicaid is being billed for that through the school. I never knew that.
Okay, so PCF is not paying for that care.
Not the school part. They're paying the private part, but they're not paying the school part.
Okay. You have anything else you want to share with us before we let you go?
I'm just here to try to help support the kids that are, not like Riley, that are the ones that are being born into situations like him. Is to try to make things better for these kids.
Okay, thank you for coming today. I know it was a long trip. Senator Alain, you have a question for the panel before she leaves?
Well, more for Ron, I guess.
Okay.
Do you
Why don't we does anybody else has any question for
No.
Ms. Frugier?
Ms. Frugier, thank you.
This
for
is-
Oh,
coming.
Mr. Frugier?
Appreciate your bravery.
No, this is her attorney. He just wanted to say a few words.
Okay.
Morning, Senators. Pierre Gremion. At this point, I'm just helping the Frugier and Riley with their future medical care, helping them get a new van, helping them update their equipment, and then we're in the process of working on home renovations. The reality here is a lot of the patients who are catastrophically brain injured, they're not aware of everything that the Patients' Compensation Fund can and should do. And so, really at this point, it's very important for everyone, and Senator Johns, I want to address his point, but it's very important to understand overall, what we have is a system of where the $500,000 of general damages is paid, that case is settled, and most patients and most clients, like Riley, end up as a future med claimant, meaning that the Patients' Compensation Fund has the legal obligation to pay for all future medical care and related benefits for Riley's entire life. And that's a typical situation.
With no cap.
With no cap, exactly. And so I will tell you, and this is very important, and Senator Johns brought up a great point. Overall, the Louisiana Patients' Compensation Fund, the Oversight Board, the Executive Director, Ken Schneider, they do a really great job. They really do. They reach out. They do a lot of stuff. Now, in Riley's case, we're just asking for a new van that's a better quality van, simply because part of the wrinkle in the PCF providing vans is that the relatives, the parents or grandparents in this case, they're responsible for all the out-of-pocket repairs to a van. So, you know, if you buy a cheap van, you end up with more repairs. So that's the only thing there. But again, I would say the payment of future medical expenses by the PCF overall, they do an exceptional job. They really do. And
those costs
very,
would also include modifications to a home or a bathroom or hallways or access to the particular home?
Right, and just to be clear, I did not handle Riley's underlying medical malpractice case. I am just coming in as their attorney to help them to request the proper home modifications and pursue the process through the PCF. But Senator Johns made a very important point about a future med claimant who was, as I understand, being familiar with that case was a child who was brain damaged and remained on a ventilator for 27 years. And yes, the benefit of having $12 million paid out is huge. But there's one thing I want to point out in that although the PCF fulfills their obligation very well, that the timing of the parents or grandparents getting a lump sum of money for these catastrophic, again, I'm talking about the children that meet the criteria of this bill that's before this committee, the catastrophic brain injured children, the timing of them getting the financial resources to pour into these kids is critical. And let me bring this home because I handled a case back in 1997. Mom's pregnant, fraternal twins. She goes to the hospital, and while she's at the hospital, she has a uterine rupture. The girl baby dies, the boy baby survives. We get the records, go through it. The medical review panel unanimously finds the hospital's at fault. They did not have the ultrasound tech or the equipment available for the doctor to make the diagnosis timely. So the baby boy is born brain damaged, profoundly brain damaged, spastic quad. Now, what's important is a couple of things. It was a unanimous medical malpractice opinion in that it was brain damage. It would fit within the definition of this bill. But what's important is he's catastrophically injured. His parents are trying to figure out how to care for him. Yes, they are able to try to do things, but these cases do not settle immediately. Okay, and so what happens is the doctors at Children's Hospital, the little boy who survived this malpractice is Casey. The doctors at Children's Hospital in New Orleans tells the mom, look, he's about 2.5 years old at this point, says, look, just take him home and love on him. We don't know how long he's going to live. He's never going to walk, never going to talk, and he's never going to feed himself. So I got many phone calls of this mother crying. Now, fortunately, in this case, and the reason I'm telling you this case that happened back in 1997, fortunately, we were able to get the case positioned because it was a unanimous opinion and settle the entire case. So we settled the entire case. So with those financial resources, Mom, who was a paralegal, quit her job and rendered full-time care. They built a therapy room in the back of the house. The horse that they would get this therapeutic horseback riding once a week, they bought the horse. They put a swimming pool in the house. So to get the financial resources early when the children are young, this child, Casey, was 3.5 years old. Remember, this is the kid that the doctor said, never going to walk, never going to talk, never going to feed himself. We're able to get some financial resources up front by settling the entire case, future medicals, general damages, everything. Builds the therapy room. Instead of him getting physical therapy and OT and speech 3 times a week, he got it twice a day. So the picture I'm painting is the mother and the father poured the therapies on this kid. He's 3.5 years old, poured the therapies and treatments on this kid. So what ends up happening is Casey is 19 years old now. So not only did he live very long, but what has happened is everything has changed. He's a black belt in karate. Okay. He's a motivational speaker. He goes around to elementary schools. He still walks a little bit funny. So he's black belt in karate, a motivational speaker. He's doing college-level work, schoolwork. His mother homeschooled him. And he certainly feeds himself. So the point of me saying this is, and what's important about this bill, that it affects a small class of potential plaintiffs, these children who have this catastrophic brain injury. And based on the statements made by the Patients' Compensation Fund, it's only four a year. And so what's critical is when you get a lump of financial resources initially, and you have well-to-do, very focused parents, you can make all the difference in the world. Casey is a black belt in karate. He's a motivational speaker. He's doing college level work. His entire trajectory of his life has changed. Why? Because it started early on. And one of the points of this bill is if you get a unanimous panel or unanimous verdict at trial, and you're able to get general damages in a substantial amount like this, the general damages are not, the family's not just going to sit around and just enjoy the general damage money. They're going to put it to work in caring for this child, traveling, doing whatever care. And the point is, and getting back to what Senator John says, the patient's compensation does a fantastic job, but they reimburse for conventional medical care. Some of the care that Casey had was acupuncture, the massage therapy. I remember asking for the pool, for the PCF to put the pool in, and they kind of, in another case, and they laughed. Well, of course, the PCF's not going to put a swimming pool in, but the aquatic therapy, these water therapies were important for this patient. So the point I'm making is not only is the raising the cap and getting this amount important, but when the parents or the grandparents have these resources, they can change everything for the patient. They really, at a young age, you can change everything. And so the point here is that, okay, as the PCF stated in their testimony in Jude A, that they may, if this bill were to pass, they may have to raise rates 4%. Okay. Well, if according to them that there was only 4 patients that would fit this criteria a year, we're talking 4 patients at $5 million apiece, that's $20 million. Their investment income alone would cover that. They would not even need to tap their claims reserve money because what they're making on investments would pay for that. But the reality here is that we're just asking for, in these very small class of patients, that they be given a chance. Not every patient is going to end up with this type of miraculous turnaround story like Casey. The kid who the doctors at Children's Hospital said, just bring him home. We don't know how long he's going to live. He's never going to walk, talk, or feed himself or anything. We're not going to have every case that's going to fit like that. Rebecca's case may not fit that, and it's not going to fit that. But what we're asking for, an important part of this bill is it gives them a chance. It just gives them a chance. If you're able to have such a clear liability case to where you get a unanimous opinion or unanimous verdict, that just to get a chance of those resources in the right hands with a motivated, as I say, mothers can perform miracles. I watched Casey's mother do it. And this is why, I'm here today to testify, have the privilege to testify before you. And so, again, in terms of paying the future medical bills, like you mentioned, Senator Johns, absolutely right. The fund, it's unlimited, it's uncapped. They do a fantastic job. But in these catastrophic brain-injured kids, there are therapies and treatments that are on the cutting edge that the PCF just doesn't pay for. And I think to give the parents or grandparents the opportunity to try everything possible to make their child better is really what we're talking about. So,
okay.
Again, thank you for the opportunity to speak.
Thank you for your testimony today.
Thank you.
Okay.
Thank you.
All right, Ms. Frugier, I think that no one else has questions for you. If you need to get
Thank you.
move on home. Senator Gaddy, do you have anybody else that'll be testifying? If you're here for any other bill except this one, we will not hear it until after lunch. Because the committee members, we're going to take a break for lunch after this bill's over. What's that? Okay. Good morning. Good morning.
My name is Jim Click. I'm an attorney, also that does medical malpractice.
Okay, let me just interrupt you for 1 second because I think Senator Ale has a question.
Just a couple of questions
Sure.
for clarification, really for, I guess for Ron, but either one of you. This future medicals, is that, that's paid Ryan, if somebody sues or starts a lawsuit at this point in time, and there's a settlement 5 years down the road, the 5 year period of which the lawsuit is going on, do they backfill for? Is it considered future medicals because they started at that time, or is that under the $500,000 cap?
I don't know the answer to that.
No, the future medical depends upon how much the future medical is. If the future medical in the general damage award is less than $500,000, then it's whatever it is, okay? If it's more than the general damage award and the future medical up to that point is more than, then whatever it is more than, it's not capped at that point.
So you get say that the claim is worth $500,000, and I've got $300,000 worth of medicals during that period of time while the suit was going on.
Correct.
What does he award?
He gets $800,000.
He gets $800,000.
Yes.
So they do cover the medical. So that is considered part of the future medicals. What is going on during the trial?
Correct.
Okay.
And
My next question, and this is just mainly my ignorance. I'm not an attorney, and I'm just trying to figure this out. Ryan, you said you settled your future medicals.
Correct.
So when you do that, you take, I guess, a lump sum payment?
Correct.
Okay. But the risk of the child living longer than anticipated, the risk of things changing into the future and getting worse, the risk of all of this.
Falls on us.
It falls on you.
Correct.
But there's no ability to revisit it or anything else. Once that settlement's done, you're assuming, by taking that amount of money, you're assuming the risk into the future of what the medicals will be.
Correct.
No,
Correct.
no crawback, no nothing.
No, sir. And that happens in every case. When, like an 18-wheeler case, if you got hit by an 18-wheeler, there's no crystal ball. You hire a life care planner to look at the value of your medical care, extrapolate it out with inflation and what's more probable than not standard of what you would need to get through the rest of your life. And if that number is $6 million or $600, and that's what the jury awards, or that's what you sign on the dotted line. If it's $900, you eat the $300. If it's $200, then there's a gain to your family of $400. So it's a risk on both sides, but it gives you finality. What we wanted in our situation was we did not want to have to go before any board and argue whether our daughter needed a Keppra versus baclofen. We wanted that to be in our favor, and because Susan and I were financially able to do it, we could calculate that risk and take some of our investments coupled with what we settled for and hire a nanny that had 25 years experience with terminally ill kids, and she didn't go work for $7.34. Miss Kathy's worth more than what I pay her,
Hope she's not listening.
Yeah, she's listening. She's watching. She's been texting me, so I got to be careful. She loves me, and she's the best person in the world, by the way, too. But she has 25 years working with terminally ill kids for the state and 10 years working with kids like Rebecca. So, when you have those opportunities come up, you can't say, hey, will you take $7.23 an hour?
Yeah, no. I was just wondering. I'm trying to wrap my head around who assumes the risk after you make are they contingent settlements that you?
I mean, we
really?
didn't.
No.
It's
a any or all type of deal.
I'll tell you what we went through, Senator Lyon, because I want you to know it's kind of important. We were told Rebecca probably wouldn't live a couple of years, and we had suffered so many financial damages because of this. I just said, look, let's just get this behind me. Whatever they'll take, whatever they'll pay, don't negotiate too much. We were going to Dallas Children's. We were thinking about going to Phoenix. I mean, we were really in a time where I could care. I mean, you're gonna get $500,000 plus medicals for your kid's brain and negotiate over the future medicals. I said, come on, let's just get this over with, because I could borrow somebody's plane and go to Phoenix. I didn't need to get the PCF. I'm not like Riley's grandma. I don't mean that in a bad way.
Right.
But I wasn't going to put my wife in a situation where she would have to beg for baclofen, which is off the chart on the workers' comp guidelines. We just go pay for it at Walgreens.
I just was wondering who assumes the risk, and you answered my question.
No doubt it's the parent. And that's why so many parents who who go through this, they never settle their medicals because there's the huge fear factor. And what if we get $2 million and put it in a medical savings account, and then that runs out before they die? And if they don't die before the money runs out, we're stuck. And then technically they start using Medicaid, which is the burden of the state.
Yep.
So what we decided to do was just basically, we met with our families, we made the decision that was best for our emotional and financial situation to put this behind us. I don't know how many people settle their future medicals. I don't know how many people stay on the pseudo workers' comp system that there is, and that's why I don't know the answer to that question. So I appreciate your question.
Yeah. Again, we applaud you for you and Susan's bravery.
Thank you, Senator.
Yes, sir.
Yes, Senator. My name is Jim Click, and I've been asked here. We hope to have Professor Caples to come here today. He has done investigation, and there's a report that he did. It's part of the materials. It's actually the first part of your materials. It's not in the blue binder, but in the big materials that he gave you. There's a whole report where he addresses a lot of the economic issues. But what I've decided here to do today, and I'm an attorney, I'm going to try to be a little bit of an economist. I'd like you to look at the number one tab. And the thing that strikes you is that the number of medical malpractice claims have dropped dramatically since 2001. You can see it's almost a 50% decrease. The filings of claims have gone down from almost 3,000 to approximately 1,400. So there's no big boost of medical malpractice claims. You look at the next tab. This shows the full enrollees of the Patient's Compensation Fund over that same period of time. And you can see that the number of enrollees has dramatically increased. It's gone from, in the year 2000, we have approximately 14,000 enrollees. And the year 15,000, last time they took it, it's open to 23,000. That's about a 65% increase in total enrollees in the Patient's Compensation Fund.
Okay, but that's due in part to the fact that we've expanded who could become a member, right?
Right. Okay. And that has increased the number
total
of people
revenue
that can take any kind of increase. Now, let's look at surcharges, which is the next thing. In the last 5 years, surcharges for physicians have dropped between 32% and 45%.
Can you explain to the committee what a surcharge is?
The surcharge is what the PCF charges.
Oh, just the regular premium part.
Right, it's the premium of the PCF. See, this bill would only affect the PCF, all right? They already have Lamico. Lamico's charges also have been going down too, but that's separate. PCF here, last 5 years, their surcharges for physicians have gone down between 32% and 45%, okay? And that's because you've got an increased number of people.
And members, just to make sure everybody understands it, when you it's like a premium on an insurance policy. I know it's not exactly the same thing, but it's something that you pay on an annual basis to become a member of PCF to get the protection of the PCF.
Exactly. And then here I have is the tag 4 is the last annual report, and this is just a letter that goes to various representatives. And it talks about the actuarial liabilities. They looked at the total actuarial liabilities of the PCF as they existed at the end of the year in 2014, and they said it was approximately $756 million. They have in assets at that time over $900 million. Okay? So they had an excess of approximately $144 million. It explains, so they have this surplus of $144 million. That's in 2015. You want to know how they do it? Okay? You look at the next page. Total income that they got from filing fees and surcharges was 172 million, or 173 million closer. They had 20 million in interest that they earned. They paid out everything, claims, administration, everything like that, $125 million, okay? And so they had 193 million, they paid out 125 million, so they had approximately 68 million in surplus for that year alone, okay? And if you look at my last page,
I'm assuming that's why their premiums have gone down.
at the same time premiums are going down, they have been able to build up. And if you look at the next tab, you'll see that their surplus has gone up. Their assets have gone up every year at the same time. The premiums have gone down. Liabilities have remained very stagnant, in fact, actually dropped in 2015 by approximately 22 million. Their surplus has gone up, and if you look at note number 3, the last report from the PCF, March 2016, their assets now stand at over $1 billion. So from the time that last report, $900 million, $1 billion, they now have a surplus of close to $250 million. And this bill, they talked about this, the interest payment alone could take care of the maximum recovery that you could see. You're setting a maximum for what these parents are going through. A jury could decide much less, but the maximum could be covered just by their interest. And unless there's some questions, I'm trying to be short and sweet.
No, I understand. And we appreciate it, but we need to stick around because we have a few questions. Senator Appel.
Thank you. I'm doing a little bit different math in my head. My math is interesting to me. We're talking about a cap currently at $500,000. What would you say a lawyer's, contingency fee on that be? 40% if it went to hearing?
Yes.
What would a lawyer get? About 40%?
Yes.
So that's $200,000. If we kick it up to $5 million and we stick with the same 40%, that's $2 million. Now, do you think lawyers are going to do that much less work, or that much more work for that change?
Well, the risk involved in these cases when you take
But you were taking the case at $200,000.
Right.
So now you're going to get 10 times that much fee, and it's the same risk, and presumably, there's also a degree of care that you're supposed to provide to your client. Presumably, you're going to do the same amount of work, whether it's a $500,000 cap or a $5 million cap.
Correct.
But your fee goes up 10 times. Is that... Why wouldn't the fee be proportionate to the amount of money the person recovers? In other words, the amount of work necessary for the person to recover.
Because there are risks involved, and then many times these cases end up being a zero. We end up getting nothing.
But you would have done that at $500,000. You have the same risk. So you're going to deny, today, lawyers are going to deny people legal services because the risk is there?
That's the reason why that we take these cases, is so that we can, where these people are so badly hurt.
I understand that. But the money's not going to the people, the money's going to the lawyers.
It also puts in, instead of putting in $100,000 or less into their pockets, at the end of the day, after expenses and all that, it's going to put in close to $3 million in their pockets.
Right.
And they're going to be
and
able
the lawyer's
to
going to get $1.8 million more for doing the exact amount of work that they did for a $500,000 cap. To me, I'm just curious. That's my math.
Well, you do that math, yes.
I'm assuming for a $5 million case, there'll be you would be more willing to invest in experts and what have you.
I'll just say this, because I do brain injury cases, and I will tell you the last brain injury case that I had to handle for someone that looked like you and I,
sure,
that was hit by an 18-wheeler. You know, we took depositions all over Texas of experts. We had to take every
You
doctor.
wouldn't have done that at the $500,000 cap?
Well, that's the whole point. You do it at the $500,000 cap,
Okay.
and that costs so much money that sometimes I sit people down that from my church that come to talk to me, and they have a $200,000 medical malpractice case. I'll say, it's going to cost us so much money in cost. We talked about future medicals. We've talked about the
Now, you're talking about cost in excess of the 40%?
Yes. I mean, depositions.
so that's just-
filing fees. Experts to fly in
Understand.
from Maryland because no one in my community will testify
And you
against
wouldn't
a
have
doctor.
done that at $500,000 cap
Do
as
it
a
at
good
five-
practicing lawyer?
We do it.
But so that's the same amount of money at the $500,000 level. Now all of a sudden we're going to jump it to $5 million. Those costs are fixed because that's the same cost you were
Oh, I
going
see
to do
what
at
you're saying.
$500,000.
Let me
But
give
the
you
fee for the lawyer goes up 10 times.
let me give you a proportion of scale. You spend that money on cases that you don't win, that are obvious malpractice. My friends that do this kind of work, they may do hundreds of these and only win a small percentage of them. But you have to spend the same money on each one. So you're right. I mean,
But I mean, we've been doing this for how many decades? And there seems to be no dearth of lawyers willing to take those cases.
well, I'll tell you what we see in malpractice and workers' comp. You can't find lawyers to take those kind of cases. That there's very few people that take those kind of cases because the risk is high, the cost is high, and the likelihood of recovery, even if you win, is low. So,
But I guess my problem is the money's not going in the pockets of the people like that lady that was here. The money's going in the pockets of the lawyers.
Well, and-
large chunks of this money.
and I tell you,
And and the lawyer's doing the same amount of work, whether it's a $500,000 case or a $5 million case.
I'm going to tell you, Senator, I had no problem paying my attorney the fee that he earned.
I understand.
I did not
No, I
flinch
understand,
at it.
and I have no problem
He sat
paying
me down
a fair fee. But when we're on these
after he-
contingencies and you're just multiplying the size of the fee,
Well, I will tell you that sometimes the defense attorney representing the hospital
I understand.
receives much more. His firm
I don't
receives,
doubt that.
you know, because you've had to
I
pay
don't
defense
doubt that.
attorneys before.
I'm not disagreeing with you.
Think about if this went through arbitration, how many years I would have had to sit with my daughter, and they just kind of hope she dies because when she dies, the value
I'm
goes
just
down.
wondering if if this is the wrong approach. If we shouldn't be talking about some kind of no-fault coverage rather than this procedure. I mean, if the end game is to get the money into the pocket of the injured family,
Correct.
not the party, but the family,
Correct.
then it seems to me we're going about this the wrong way because most big chunks of the money are going straight to lawyer fees and other costs. It seems to me we should be talking about a no-fault system where if it's a clear problem, that's it.
So
It's over.
so you'd be for if you got in a unanimous panel, the family would get the value of the life care plan and whatever the jury awarded, whether it's $2 million or $50
if
million.
you can eliminate a lot of the legal fees out of it, I think there'd be some model like that you could do. But my whole point is this: I just don't see. I would almost be willing to put some kind of amendment. I know you can't do it to limit legal fees in these cases. To me, if the lawyer's getting paid X number of dollars at $500,000 cap, and it's going to be 10 times that at the $5 million cap, I just don't think it's fair to the families.
well,
and
I'll
I
tell you-
don't know
I'll
how
tell you
to
what's-
do that.
well,
but
I'll
I'm
tell you
just
what-
telling you the way I feel.
Here's the problem, that if I go to the hospital in my area and say the most you can spend in defending a $5 million case is X, they're not going to be able to defend themselves if we start capping attorney's fees. Now, if you cap both sides and you say, look, the most y'all can spend on this traumatic brain injury case is $50,000 a piece, that's your fee, a flat fee. Well, nobody's going to defend the hospital. You see, and you can't let a hospital have unlimited.
The gentleman just pointed out there's a substantial surplus in the funds, and they have more than enough to cover their defense.
But I agree with your point that it is.
I just think this is, and I'm not pointing at your bill. I'm just talking more in general. But when you start talking about massive increases in legal fees that don't go to the family, and yet, in my mind, would it's the same amount of work to give, quality service? I don't get it, but that's just me.
Does go to the families.
Yeah, but you're right. If that's something you and I can work on, I'd be glad to work with you on that, because you've had concerns with that before, and we've shared those concerns. And this cost is outrageous, and I have to work in the confines of the Malpractice Act.
No, I understand
with this bill.
I'm not
I'm
necessarily pointing a finger at your bill. I'm just pointing out a simple mathematical fact.
Thank you.
Thank you, sir.
If there's no more questions.
Okay, no further questions.
All right. Thank you.
Just have my wife real quick.
Sure, yeah, have her come up, please. Susan?
Sorry, Susan. That's the only way she doesn't cry. So.
You guys are kind of long-winded, so I'm going to bring her on. She's not incredible. No.
Welcome to the committee, Ms. Gaddy.
And I'm Susan Gaddy, privileged to be wife to this man next to me and daughter to the Rebecca in my arms.
That was not in the notes. She just made that up. So.
I guess I'm here to speak. I think oftentimes we're going into global things here, but I'm here to speak specifically to the pediatric neurological injury component for a child. Sorry. Yeah. It's been a long morning. As a psychologist and an attorney, I think we were unique in the fact that we were victims as well. So when you have a child, especially a baby that's injured, the first year of life is so critical and so unknown. Before we're psychologists and attorneys, we're Christians. So we believed in all kinds of miracles and all kinds of things that could happen, and we believed our faith was greater than a mustard seed. And I've also said many times that, you know, your faith and your prayers are great for things whenever you pray for healing, and there's a lot of reward that comes when those prayers are answered. But there's a greater faith that comes from knowing that you want these things for your child and you want these things for your family, and they're not given to you for a greater purpose. So I believe that maybe she's here today to help whoever is watching in this panel see the greater purpose that can come from her life. Now, within the first year, knowing the power of prayer, that superseded my knowledge as a psychologist, if that makes sense. So you spend the first year of your life watching and waiting as you watch your child grow, and you watch for the smile to come, you watch for a roll to come. You know, all those little landmarks that parents love to see, the first of everything when everybody takes the pictures. For my child, I never really got a first. She has a developmental level of less than a 1-month-old because she cannot even smile. But as you're doing these things, I think I had to leave my job as an assistant professor at LSU Health Sciences Center. Ryan then needed to leave his job as a practicing attorney, which he had worked years to establish, to become a workers' comp judge solely for the insurance, because my job was what had provided the insurance prior to this time. But I could not, in good faith, leave my child with my parents for an extended period whenever I traveled to DeSoto Parish and do these different things for grants for Department of Education, because I did not want to be an hour away if a seizure happened or if anything happened. I needed to be there immediately. So we made all these sacrifices because that's what you do when you're a parent. You sacrifice for your child. And I'm deviating greatly just because of the things. So during this first year, even though he is an attorney and I'm a psychologist, your demands and your focus are so completely on your child that really, even with our resources and with our education, we needed to have an attorney to navigate that process because it's too litigious, it's too detailed, we don't want to see depositions. Like, I still haven't read whatever is in front of you from the medical review panel because I don't like to see those things. So that we could just focus on her. So while what is in place currently provides for their medical care potentially for life, it does not really provide for those kinds of things and those kind of sacrifices that families do make for these children that happen as a result of these things. Rebecca now is 9 years old, we have been told, just so you know the extent of her injury is great. And like, I believe Ryan kind of stole a few of my lines, because the best way I can say is when your brain is hurt, everything is hurt. So I think that's why this is such a unique thing for a child with a brain injury, is you watch these things go, because you never really know what's going to come of these things. So her current, you could give her any kind of list of diagnoses that you want. She has Lennox-Gastaut syndrome, which basically means she has epilepsy with a failed list of medications that exceeds anything, because nothing works, because she continues to have seizures regardless of the medications that she receives. For example, one of her medications, because we always have to try the latest and greatest because nothing works for her, one of her medications costs in excess of $1,000 a month. That's one of her 4 seizure medications. And by the way, Ryan, baclofen is a muscle relaxant, not a seizure medication. Keppra is on the failed medication list. But so she does have the seizures, which are a great cause of concern. Also, many of you come and try to look at her, which is nice, but she does have cortical blindness. So she is unable to see you, but her hearing is in perfect condition. That's why when she hears different voices, she will change her demeanor and listen to you. She has all kinds of, I could go on about the medical conditions. The greatest thing is if you look at her, she almost looks like a question mark at this point. We've gotten to the point where we cannot even make her comfortable because of her hypertonic. Her muscles become so tight and so flexed that there's no way to help her with that. There's no medication, there's no surgery, there's nothing that you can do. And as a result of those muscles staying in such a contorted way, it then twists her skeletal system as well. So when you look at her, she's pretty much in an arched back position, and the only way I've been able to keep her comfortable since birth is to have her past a 90-degree angle to be able to keep her comfortable at all. So we're now at a point where I cannot even get her comfortable for many periods, but it's always been the point with caring for her to put her in a good position to do things that are good for her. Long-term care puts her in short-term duress and pain. So it's always an ongoing battle as a parent. So to try to find someone to care for your child, to do those things, this is why so many parents lose their positions and they stop working and they find grandparents and they find parents to care for these children, because I can still remember the day, Miss Kathy, if you're watching, that you came to me, and that's a story that I could tell many of you longer, that's God ordained. I remember telling her I just want someone who would love my child, because a brain injured child, many people would look at me and say, oh, I've had my baby had colic too. A brain injured child is not a colic baby. A brain injured child is like a colic baby on steroids, because they scream all the time. So you just want someone to love your child. So you make all those sacrifices to do all of those things. And you do it willingly, and you don't begrudge it. And I really didn't want there to be a fault for this. I didn't want the money. I wanted to know that everything that could have been done for her had been done for her. But with those decisions that I have to make, for example, as she sits in a chair here crying, and I apologize for that, if I don't leave her in that chair for a certain amount of time a day, her muscular position gets too bad and it worsens. So oftentimes I feel like I'm looked at like a heartless parent, like, why aren't you doing something for your child, when in fact there's really nothing that can be done to help her, which is hard. She's even been described by one physician, by one pediatric neurologist, as having a less than 0% quality of life, because basically what happened with Rebecca is she's so injured that your body kills off what it doesn't need first for your brain activity, right? So it reserves your breathing, your heart rate, but another thing it reserves is your ability to feel pain. So while she's unable to do a lot of these things, she does feel pain. So, and like, there's no amount that can compensate for those kinds of things, but I guess I want to give an understanding to this committee that the burdens of caring for a child are so much more than the financial part of it. There's behavioral parts, there's social parts. We go on vacations and we're not really able to take her. We don't take her to restaurants if we can help it. We don't do a lot of different things, mainly because she doesn't like it. The fact that she's here and has been here twice is very rare for her, because she likes to be where she knows. And the best way we can say whether or not she likes something is whether or not she's basically quiet. She likes me better. So I wanted to say a few things, and I'm going to lose my notes here. You know, so socially, she's not. When we go places without her, I feel like our family's incomplete. When we go places with her, I feel like it's too much of a burden for our family to carry. Emotionally, spiritually, all these different things happen, but I think the fiscal matter is mainly brought up just because it helps to ease these other things, because I think one of the highest divorce rates that you'll see in families are families of children with special needs, because the stress that comes with caring for a special needs child is so great. Trying to see what else. I think, and it's ongoing. It never really ends. I thought it ironic that yesterday my kindergartner woke up next to Rebecca, and she looked at me and she said, "Mom, will Rebecca ever get better?" And I had to look, after 9 years of this, and still look at my kindergartner and say, no, not this side of heaven, but she will be better in heaven. And so there's a lot of lessons that we've learned from this. There's a lot of hope, and there's a lot of blessings that come from this child. So I don't like to come up here and just say the burdens, but I feel like part of my responsibility is to share the burdens with you. But the burdens are ongoing, as well are the blessings that come with it. But I do think that there is an injustice in this system, and I don't really know what the answer is to it. I think many of you have pointed out that there's many injustices in it. But I feel like the last time I was here, I heard someone come and testify at the end of it, and I don't know that she realized how offensive the comment was, or maybe I'm sensitive and I took it offensive. But I remember her saying she was watching my husband's race because they knew that if he got elected, something like this would be coming down the reins. And you could probably watch the video. I don't know who she is, whoever you are, sorry, but it was offensive. And the only reason I think I found such offense to that is because our situation must be well known enough that there was such a great injustice in what happened to my child and into my family that they could foresee that he would be trying to do something to make it more fair for others. So our goal in being here, we really don't gain anything by this, but our goal is really to try to prevent this from happening to people in the future, and also to advocate for those children who cannot advocate for themselves. And I'm sorry if that's a little bit scattered, but Rebecca next to me kind of distracts me a little bit.
You're good.
But do y'all have any questions for me, or no? Okay.
Yes, ma'am. Thank you for your testimonies. Senator Hewitt.
I'm not going to really ask any questions, Susan, other than just to tell you and Ryan again how much I appreciate your testimony and your courage. Mm-hmm. And I do think that we're all called to, we're all a product of our experiences, and so I think that, your comment about Ryan, his election, and whatever. I mean, I think that we're all called to offer help in areas based on our experiences, and so. I appreciate you all sharing your story, and I have no problems whatsoever, with bringing the bill forward. I'm not sure that I'm completely on board, to be really honest, mm-hmm. but I respect the fact that you all are advocating for other children, and just deeply respect the both of you.
Thank you.
Thank you, Senator.
Senator Barrow.
And I don't have a question either, Mr. Chairman. I just want to make a comment. As I was listening to you, Susan, I remember when I first saw this book called When God Doesn't Make Sense. Mm-hmm. And, when you have certain things that happen in your life, you wonder why. Mm-hmm. And we have the right to wonder why. But everything that he does has a reason. And even in this, as I listen to your testimony, you understand that this really is not so much about you guys, but other individuals and families who can benefit from the change that is necessary. And so I want to also echo the comments of Senator Hewitt, and just thank you so much for your testimony. And I do have to apologize. I do have one question. Mm-hmm. So the medication that she has to have now, that was never incorporated in the settlement that you guys received. That is now being paid, or you guys have to pay it yourself, or is it through?
It may have been. We don't know because we didn't partake of that. We did settle the future medicals at the time, and we paid our attorney fee out of our future medicals as well as our deductible. So, but we did, thanks to my husband's great new job, mm-hmm. once we meet the deductible, I presume that more of that will be covered.
Yeah, but I mean, yeah, great.
This
yeah,
is
great.
this is why all of a sudden the $16,000 salary reward goes up about $1,000 a month. You know,
Yeah.
for us as individuals. So
I totally get that.
$12,000 raise right there just happened. Sorry for whoever's paying the insurance for you guys. You just took us on.
Yeah,
So.
but prior to coming here, prior to coming to the legislature,
It has been a ongoing battle in terms of we need to make sure that we can never ever leave an insurance plan without another insurance plan in place. And even though we are supposed to make sure that we never do that, we have done that on faith a couple of times and paid out COBRA extensively. Our case settled relatively quickly because it was so clear. If you read that, even one of the physicians, I mean, they didn't just agree with the points that were brought to the panel. They added additional points of concern as to points where neglect had happened in the case. But by the time, what was that, just about a year and a half or 2 years into her life? How old was she when we settled?
2.5.
She was only about 2.5 years old, and we were in debt.
yes,
We were borrowing from my parents. We were borrowing from his parents. And it was really just a matter of give us the comfort right now so that we can invest it and we can build on it. And I had this wonderful asset of a husband who I knew would be able to take that and invest more in it. And honestly, that's what he did. He took
Yeah.
it and he spent it wisely, and we've made money from it. And we've probably superseded that by paying for the health care and the standards for what we see fit for our child versus what a PCF would see fit for our child. But that was our goal in accepting it, as well as we wanted to be able to dictate the standard of care for our child. And we just, honestly, it was a leap of faith and a trust of God that we did that. So it may have covered that medication. It may not have. I really can't answer that question, but I do know that it is a hefty bill. But I did pay $0 for my gabapentin yesterday, so our deductible may have already been met. So that's good news for us. But there's a lot.
but for other families,
For other
families who may experience that, then
Even when we did, so we had health insurance through Ryan's firm and through other things is how we managed to keep our health insurance. But as we had that health insurance, even after we'd met our deductible, I believe that one was still $400 a month. And you have to understand, she is on, she's on, well, the seizure medications, I'll just say it out loud, are Onfi, Trileptal, and I'm going to go bring it up here. And there's another seizure medication. And she's also on baclofen. She's also on Xanax. And we've also recently started Valium because her muscles are so are causing such great pain for damage to her skeletal system that we're trying to find anything to be able to help her relax. So she is on about 4 to 5 different seizure medications and a muscle relaxant, as well as different things that we have to use to regulate her gastrointestinal system.
and you know, I can't imagine what you guys have been through, but I certainly want to applaud you and just thank you for bringing it forth in hopes that, you know, other families don't have to experience this. I mean, you guys seem like you were able to kind of to maneuver, and you were able to do various things where it wasn't as onerous, I guess, as it could have been, because, you know, I've heard of stories where individuals actually almost end up homeless, and, you know, just different situations where it really becomes really, really tough to do that because you're doing everything you can to make sure that your child, you know, is in a better condition, and they're not in pain, and they're not hurting, and all
Well, maybe
those
one day I'll
things.
write my own book so you can read that one on the different ways we've been blessed and carried through this process, because there are too many to count.
Yeah. Well, thank you so much.
Thank you.
Senator Hewitt?
Mr. Chairman, I have some questions at the appropriate time for the fiscal office and maybe the insurance folks, if there's anyone in the room that can answer a few of those kind of questions.
Sure. We have I think the fiscal office is here and available to testify on it. And if you don't have any other questions for the Gaddys, what I might do, Senator Gaddy and Mrs. Gaddy, we might get the PCF and anybody else that's here to testify on the bill to come up at this point.
And just for you can go ahead and go, honey. The point of clarity, we have these binders that have a lot of information. We put it all in a thumb drive for each member of the committee. It has an index. There's 2 binders, and we also have a so that y'all don't have to carry this binder around with
Right.
you. And so that was, so we'd like to
And I think everybody received the jump drive. I think it was distributed to everybody.
Drive somewhere put in the record of the bill. Thank
Okay, sure. And then we'll have you come back up and close in a minute. I guess can the PCF, Schneider and Mr. Schneider and I guess just Mr. Schneider.
Thank you, Senator, for not asking me to carry around that binder and giving it to me on a jump drive. All right, sir, would you just maybe walk us through the fiscal note, please, as a way of starting?
Sure. Matthew Labriere, Legislative Fiscal Office. There's the original note that's online, and you also have the engrossed with proposed amendments. There was also an engrossed version, but the proposed amendments took that one off. If we're going off of without the amendments, I'll walk through the engrossed version of the bill.
Well, just to help me, I need to make sure I'm clear on this. My understanding from Senator Gaddy that is, at this point in time, we're looking at the original version of the bill and the original fiscal note.
Yes.
Correct?
Yes, ma'am.
Okay.
We didn't know what the cost would be to the state when the original note was put out. Just that if you pay out $4.5 million more, then state costs would increase. After the bill passed committee, it was amended, and so we put out a revised note with new information that PCF will also testify to as to what their actuary calculated what the rates may increase.
And what was the amendment? Was that where the amendment was added that takes the state out of the equation, or no? That has not been adopted, is
no,
that
ma'am.
right?
The amendment that was adopted in Judiciary A was just to further define the injury and the age, and but taking testimony from PCF, we made some assumptions. If their rates increase like that, then based on the $12.2 million in insurance premiums that risk management charges every year, there would be an increase of about $550,000. And you won't see that note. That was the engrossed note. But since there was a revised note with the proposed amendment, the engrossed note went away.
I'm sorry, I get lost in all the engrossed and re-engrossed terminology still. Okay, so explain to me the number. You've got $12.2 million in premiums that you're estimating. Is that on an annual basis?
That's the 3-year historical average in premiums that have been paid.
Okay, on an annual basis.
Yes,
It's
ma'am.
a 3-year average for an annual number, 12.2.
Yes, ma'am.
Okay, so how did you get to the 500 or 550,000?
Mr. Snyder may also want to comment on that. Their actuary came up with a number of what the increased premium would be. During the testimony, we took that information and just applied it to the state's cost. So just for having the increase, and please correct me if I'm wrong in any of this, just by having the $5 million cap, your premiums would increase by 4.5%. We took that 4.5% and applied it to $12.2 million. From there, we came up with $550,000
Okay.
is what the premium would increase.
Okay, so that's the premium increase of $550,000 if the bill passes with the increased cap. So there's increased premiums assumed with a higher cap.
Correct.
Okay, and we're just talking about, again, the state's
Right, and
share, the burden of the state.
And I don't know if risk management's actuary has calculated that. It does take an actuary to do that. I'm not one, so I can't come up with a number for you.
Okay. And then the other side of this is has to do with the medical malpractice claims that the state would pay out, doesn't it?
Well, that would be built into the premiums, I believe. So if you pay out the claim, their actuary also came up with a cost for that. For every $5 million you pay out, there's a 3.6% increase. So assuming that happens to the state and we pay out one claim, that's an additional $440,000 that would be tacked on to the premiums.
That would be paid out in terms of claims. What does this mean when you say fiscal year 12 through 14, the average total of all medical malpractice claims paid from fiscal year 12 through 14 was $13.4 million. What does that mean?
That was the amount of total malpractice claims for state hospitals, state clinics that was paid out. I don't have the number of claims that was paid, but it would be the amount the claimant received.
Did those all have to do with brain injuries?
No, ma'am, that was statewide.
Okay, because that question came up earlier.
Right, and when we originally did the note, I think they were trying to look into that, and since the note we didn't know where it was going, I haven't received that information. I can definitely ask for it again.
Okay, so we don't really have a good handle on what the state's exposure could be in terms of medical malpractice claims should this bill pass.
We know the premiums will increase for all state agencies because of this.
Right. But we
we can assume.
But we don't know, again, how it will impact us in terms of claims, potential risk of
No, and that would have to be done by risk management actuary to figure that out.
Okay. Okay, thank you. I think I understand the numbers. I wish we had more numbers.
I can put more if you'd like, but we try to keep it simple.
Okay, yes, sir. Do you have a few comments along this line?
Yes, I'm Ken Schnauder. I'm the Executive Director of the Patients Compensation Fund. The numbers he's using on his fiscal note were done by my actuary. We've had the same actuary for 20 years. And what he told you was correct. Just the increase in the limit from the potential for a $5 million claim. Before one's ever paid, rates would have to go up 4.5%. That's with no claims being paid more than are being paid now at $500. And then for every $5 million claim paid, that would be a 3.6% rate increase. And that's across the board of all lines. Because I know I guess the misconception, that may be a bad word, but the misconception is that we're talking about brain damaged children from birth. And that's not the case. You can be brain damaged when you go under anesthesia at 13 to have an appendectomy. There's all kind of varying degrees of brain damage. And the numbers that everybody's been using, most of them are the PCF numbers. We've averaged over the last 20 years 6 brain damaged child claims, of which 3 to 4 were of moderate to severe nature. Senator Johns alluded to the biggest claim the Patients Compensation Fund's ever had was a brain damaged child. We have 14 claims in our 40-year history that we've paid over $5 million on. 14 out of tens of thousands of claims. 9 of those 14 are brain damaged children. And the majority of that damage is medical bills, naturally.
That's all future medicals you're talking about, right?
Correct. And there was a lot of questions about and talk about future medicals that I kind of want to clarify just so everybody knows. We operate on the workers' comp fee schedule. That is strictly the amount of money we pay for medical services. We don't operate like a Blue Cross or like workers' comp. We don't dictate what treatment the people get. Their doctors dictate what they get, and we pay. If the treating physician says they need a certain drug, we pay that certain drug. We pay based on the workers' comp fee schedule. By law, the healthcare providers have to accept that, but we don't dictate the medicine that they receive, the treatment they receive. We don't ever dictate that. Granted, as Mr. Grimion alluded, we denied the building a swimming pool for a person that needed aquatherapy. It has to be medically necessary, and we pay all medically necessary needs of children. We do pay the $7.43 an hour custodial care for parents or family members only to take care of their children. Anybody else, if they need round-the-clock nurses, we pay round-the-clock nurses fees. If they need sitters, we pay sitter fees, all subject to workers' comp fee schedule, but we do not dictate the treatment, and we pay based on those rates. Out of state, Senator Gaddy, they go to Texas Children's. We don't pay based on workers' comp fee schedule in Texas. That's Texas. This is Louisiana law. We pay an outlier. We make a negotiated price with Texas Children. As long as it's approved medical treatment, we pay it anywhere in the country, and we negotiate a fee. So I just wanted to clarify that. You heard Mr. Click talk about the money that the Patients Compensation Fund has. The hardest thing for most people to understand, and our actuary has to explain it to the board every year, but the claims we're paying today are claims from 5, 10, 15, sometimes 20 years ago. I have a claim open right now that's a 1977 claim that we're still paying medical bills on. That's how long that person's lived that needed future medical care. So collecting the $170 million we do today, that's to pay claims over the next 20 to 30 years. Everybody wants to look at the cash basis. Well, you took in 170, but you only spent 125. Well, we need that 50 to pay for those medical bills that are going to cost 3 times as much in 20 years as they do today. That's the hard thing people have to understand. Yes, the Patients Compensation Fund finally has a surplus. For years, 10 years ago, we were $500 million in the hole, and everybody, the insurance commissioner sued us. He demanded that we have 25 to 30% rate increases every year to make us whole.
Actuarially sound, yeah.
So, the board added 5% rate every year on top of what the actuary said we needed. And that was a cumulative effect over a 10-year period of time. That's what made us whole. That's why we're able to give very large decreases in the past 4 or 5 years, because we finally got to where we needed to be and claims reduced over that same period of time. So I just kind of wanted to put everybody in perspective as to what's been discussed, and I'll be glad to answer any questions.
Yeah, I've still got a list, Mr. Chairman, if that's
Go
all
ahead.
right. Questions have been kind of accumulating here. So, what type of doctor would, let's see, I don't know how to ask this. So the children that could have brain injuries of the type that we're describing in this bill, what types of doctors are those typically? I mean, are they all OBGYNs or?
That's the more common, and that's the one people think of. Mm-hmm. But it can be an anesthesiologist. It can be, I hate to bring this up, but over the past 2 years, I've had 2 brain-damaged children at dentist's office from being over-sedated. Emergency rooms, when people come in, there's varying degrees of, an internist, just a family practitioner can cause brain damage to a child. So that's why the actuary figured rates across the board. Naturally, neurosurgeons, orthopedic surgeons, anesthesiologists, OBGYNs, that's the more common that you would think, but there's nothing definitive about who's going to develop this type of claim.
It could be anybody in the process.
Right.
Okay, so what I'm trying to get to is, I think you said earlier that should this bill pass with the higher medical malpractice cap of $5 million, you'd expect an increase of 4.5% on their premiums, right?
That's if it passed. It would be an absolute 4.5% increase, and then the actuary would estimate, based on our past history, because we have no idea going forward, how many claims of this nature we would have, which in the past 20 years we've averaged 4. 1 year we had 12, 1 year we had 1, but the average has been about 4. Well, then you don't know what the dollar amount of those 4 claims may be. 2 of them may be $5 million, 1 may be $500,000 more than, depends on the severity. Right. But for every $5 million in added claims, that would be 3.6%. So let's just take 2. That would be 7.2% on top of the 4. Okay, so you're at 13% increase would be the absolute minimum the actuary told me he would figure. If it passed this year and he needed to do rates, that would be the absolute minimum he would add across the board to all lines. Now, to give you an
meaning
example.
all doctors that have medical malpractice.
Hospitals, every single type of enrollee we have. And,
Okay.
you know, for an OBGYN, that's about a $6,000 a year increase.
That's what I was trying to get to. Okay, that's a $6,000 a year increase in their premiums to
Just
cover,
to
right?
the patient's compensation fund, yes.
Okay. Would you expect I know I'm asking a lot of hypothetical questions here. Would you expect the number of cases to increase potentially just because the cap is raised?
Yeah, I believe for the same reason that Senator Apel and Senator Gaddy were discussing. If, you know, it is an expensive process to pursue a claim. If the maximum you think you're going to get is 500 and the attorney takes 200 of it, the maximum you're going to get is 300, less costs, which is going to cost you probably another 100. So you may end up with, like you heard Ms. Frugier said she had $180,000 is what they actually ended up with. Well, if the potential to get 180 jumps to the potential to get several million, yeah, I would venture to say more people would pursue claims.
Looking at it from the perspective of the doctors, do you think that increased caps would have sort of a chilling effect on doctors' willingness to take high-risk cases or to participate in, I don't know, higher-risk procedures in any way?
Yeah, I would think. I mean, most doctors, when you mention this to them, you know, OBGYNs especially, they immediately say, well, I'll just quit delivering babies. You know, that's a knee-jerk reaction, but that's the reaction.
Okay, so last question. I'm still trying to get back to how this affects the state. You're saying now, at a minimum, the increased premiums based on your actuary would be on the order of 13.2%.
Correct.
Right, at a minimum.
Well, on the state side now, the state, I mean, if the cap goes up, that's going to, and they get hit with a $5 million claim, that's going to be $4.5 more million the state would be paying right off the top.
Right.
So the premium dollars would, you know, depending on if they have reinsurance for certain levels of claims, you know, that could be a direct hit to the state's bottom line if they get hit with those claims.
Right. So I understand. I mean, so there's a claims component to our expense, and then there's the premiums, right?
Right.
Okay. So the premiums right now, I'm going to do a little bit of math. I'm not with the fiscal office, so here we go. Our premiums collected during the last 3 years averaged $12.2 million a year, right? So can't I just multiply that times 13.2%, and that would be the increase?
I would agree with that.
Okay. So we're talking about another $1.6 million in premiums that we could expect next fiscal year, correct?
If
this bill passes.
If this bill passed and there were claims made against it.
No, just increased in premiums.
Well,
they're saying they're going to increase their premiums, right? 13.2% at a minimum.
That would be if there were claims against the $5 million. We know based on their actuary, we know 4.5% for sure without a claim being made. If they're assuming two claims, and that gets you up to that would be 11, a little over 11%. If we knew what the state's average number of claims per year.
Okay, so if we had a year with no claims, then we would only have the 4.5% increase in premiums. So it's like when you have a car accident, your premiums go up. So we would wait till we had an incident, write a claim against the state, and then our premiums would go up the following year. Is that kind of how it works?
I would think so. I'm not going to speak for risk management here, but if this bill went into effect and they had a like amount increase, then to start the year would be 4.5%. If anything happened, then obviously that would be recalculated for the next year.
Okay. Okay. And then your exposure is whatever else you would have in terms of claims against you that would be a potential hit to the state.
Correct.
Okay. All right. Thank you. I appreciate that from both of you. Thank you, Mr. Chairman.
And members, not to cut off the discussion or to narrow. I mean, I realize we hear these bills because we're going to discuss them. But for everyone's, I think the author has indicated that this bill in the process will turn into a study resolution, and that the committee is, with that understanding, the committee intends to let it out at least so Senator Gaddy can have an opportunity and a venue to voice his concerns about this issue. So just keep that in mind as we proceed. Senator Barrow. No. I'm sorry, Senator Hewitt.
I'm sorry. Would you repeat what you just said? The idea of a resolution is kind of new information for me.
I'm sorry. The Senator Gaddy has indicated that his intention is to proceed with the bill, but as a resolution. But that I think that the committee, and I'm not going to speak for the committee, but they were going to give him deference to make his position on the floor with a full audience, and that he would convert it to a study resolution to study this narrowly focused situation in which damages could exceed $500,000. Whether the study committee comes back with $5 million, $1 million, who knows? I don't know, or nothing at all.
Can you do that? You can convert a bill to a resolution, or do you just shelve the bill and start over with a resolution?
Sometimes you take baby steps. Yeah. Right, you get a little bite every year until you at least get your point made. And Senator, I'm not going to speak for the committee, but I think the committee, in my discussions, thought they were going to give Mr. Gaddy that opportunity.
Thank you, Mr. Chairman.
I don't.
Hey, we don't get all that same conversation on this end of the table. I'm just saying, we're at Senator Barrow and I. We're down here. We're working hard. I don't know what you guys are doing on your end of the table, but
I'm sorry that I should have.
There's something going on that end of the table that we didn't hear.
I didn't discuss it. I should have worked the committee better than I did. I apologize.
Thank you, Mr. Chairman.
Okay. Senator Barrow.
When Senator Gaddy comes back to the table, I just want to make sure, because when I see this amendment that was being proposed, when I think it took out the state as he's doing the resolution, I want to make sure that component is added in, and I just wanted to make that comment to Senator Gaddy as he's doing the resolution. I don't want that to be omitted.
Yeah, I'm sure that the study resolution in its final version will be focused on this particular area of damages, this type of damage, these types of votes in front of the medical. This is what we've discussed, and I'm going to ask Mr. Gaddy to come forward before we take any further. But let me get Ms. Maruzak, you ready? Let's finish the opposition, and then in closing, Mr. Gaddy, we can talk about what your ultimate goal is at the end of the day, and what the committee has informally agreed to do.
Sure. Mr. Chairman, members, first of all, let me assure you this is pretty much the last seat I want to be sitting in right now. But also, let me say to Mrs. Gaddy, I am the one that said that in the other committee. And the reason I said that about this legislation coming was because then Senator-elect Gaddy had told that to my colleague when they had lunch, because they'd gone to law school together, and they had lunch together before he got elected, and he told him the bill was coming. So that's why I said that. And with all due respect to Senator Gaddy and his family, we just wanted to say on behalf of the Medical Society that we know the system's not perfect, and the study, as you mentioned, is we are happy to be at the table for that discussion. We just feel in general terms this kind of legislation to talk about one specific kind of instance, one specific kind of injury probably isn't the best way to deal with the whole system, and that looking at the whole system is probably the best avenue for all of us on both sides of the issue, and we look forward to moving forward with that. So thank you very much.
Senator Bishop.
No.
You still have a question? Okay, no questions. So we don't have any further questions, Senator Gaddy. You know, we've talked before, and I've talked to everybody on the committee except Senator Barrow and Senator Hewitt, which is pretty obvious.
Other than that
faux pas. You know, Senator Gaddy, I mean, you made some great points. I can't help but yeah. So, look, I got 3 kids of my own, so I cannot help but admire the kind of devotion that you have. I would believe that in malpractice cases in this narrowly focused area, and possibly as Ms. Marusak has pointed out, maybe the whole system, I guess, needs to look at it. It's certainly not perfect. I practice, like I said, I think I've had 4 cases in front of the medical review panel. I've been involved with Mr. Schneider on some other cases in the past. It's not a perfect system. We don't change it, these kind of major changes. We don't typically make that overnight with one bill in one session, because the implications for the whole medical system as a whole or can be seriously affected. But I think the committee recognizes that we probably need to look at these things, and maybe your situation, as unfortunate it is might be fortunate for others, in that in the future changes can be made that would make the system better and, as your wife pointed out, fairer. So with that, I'll let you. So I think the committee, once it will let you out so that you can have an opportunity on the floor to make some of the same points you made today, and then work with the groups that are in the back and those that are out not here today to come up with some solutions.
Thank you, Mr. Chairman, members of this committee. Based on the all the facts that we've derived out of this bill and just the documents that we've put together for y'all to review, this is not something we can turn on a dime and take care of this year based on just the cost to the system. But what we did today is we did what the Supreme Court asked us to do. The Supreme Court said that we have the obligation as a legislature to do a balancing test between the harms and losses that families suffer and then the rights and obligations of our hospitals and doctors. So I appreciate your time today, and I'll just leave you with this. The most common thing Susan and I get told, whether we're at church, on a mission trip, or wherever we are, even at Walmart, people say, oh, you know, God gives people these kind of kids for a reason, or they give these kids to a special family for a special reason. And there's been a lot of reasons we found out that God gave us Rebecca. This might be one of them. And so I appreciate y'all's attention today. I know you got so many bigger fish to fry in our budget process, and I appreciate you so much for your questions, for the time you've shared with me and my family today, and it means a lot to me. But based on everything we've talked about, I feel like this is such a big change to the system, maybe not as it may be too tailored and too specific. And I will agree to meet with all sides and put together any type of committee or commission to walk through this to make sure that this doesn't happen to any more babies. And if it does, their families don't have to file bankruptcy.
Well, thank you for your testimony, Senator Gaddy. Like I said, I will speak on behalf of the committee. I think all of us admire the way you've handled that situation. I know that I don't know if I would have had the wherewithal to do what you're doing today. I hope that I could have, or that I would if the occasion ever arises.
Well, I want to share this with any families that are listening. I mean, we've taught our 2 oldest kids, Senator Barrow, what you hit on is I've had to sit down with my kids and tell them the majority of your life happens after you pass away. Don't try to spread all this pain and suffering with Rebecca over the 80 or 100 years you have with her here. Said 500 years from now, you will have spent more time with her in heaven with a perfect body than you could ever spend with her here on earth. And that's the good news of the gospel. So in teaching that to families, whether it's a Sunday school class or at our church who have a child that is like this, or even a parent with Alzheimer's, you know, it's important that we know as Americans that our country believes in a certain spiritual being that we are. We're not a body that happens to have a soul. We're a soul that has a body, happens to have a body. So I would just want to share that comforting thought. That's how we make it. All right? That's how we make it through the day. All right? So... but I appreciate your comments, appreciate your kind words, and I thank you for your time.
Okay. And Senator Gaddy, so we'll let this bill out, and then we'll hear from you on the floor about your final draft of a resolution. So
Correct.
with
Thank
that,
you, Mr. Chairman.
I'd move that the bill be reported out favorably. Without objection, so ordered.